Welcome, dear judicial service aspirants. In the previous evening session, it was focused as that we have to enlist fundamental principles of our civil justice. Criminal justice and civil justice make two distinct streams of our justice delivery system. Today, we are going to be face to face with first fundamental principle of civil justice. This principle is that one who is having a civil cause is to initiate judicial proceedings. Moment one initiates civil justice, he becomes plaintiff. The initiation of justice by plaintiff is in terms of a plaint. Plaintiff is to get registered his plaint. Plaint is a technical term. Plaint is a statement of pleadings, and these pleadings are to be in respect of the facts. Pleadings are to be about the facts. Plaintiff having a cause, civil cause, is to get registered his plaint as a statement of facts. These facts shall be sufficient to lead to the cause and the relief prayed. This is the first principle. About it, the adjudicated stand is that these facts have to be true. One can plead only true facts. And the catch here is that one cannot withhold the facts. True facts of the knowledge of the plaintiff are not to be withheld by the plaintiff. The withholding of the facts amounts to a fraud. Therefore, today we are going to be face to face with the judgment of the apex court as to the law, as that withholding of true facts amounts to a fraud. And then the consequences of the fraud are that the plaint will be rejected. The plaintiff guilty of withholding true facts is not entitled for a decree, a relief from the court. Here is a lead, an enlightenment lead from Justice S.D. Anand for us all. And see, it is when you talk, you are only repeating what you already know. But if you listen, you may learn something new. When you talk, you are only repeating what you already know. But if you listen, you may learn something new. Listen to the judgment of the Supreme Court of India. SP Changasalaya Naidu versus Jagannath. It is the judgment which is delivered by Honorable Justice Kuldeep Singh. This judgment deserves to be imbibed as it is going to lay foundational principle of civil justice. Let us read. Fraud divides all judicial acts, ecclesiastical or a temporal, observed Chief Justice Edward Coke of England about 3 centuries ago. It is the settled proposition of law that a judgment or decree obtained by playing fraud on the court is a nullity and non-est in the eyes of law. Such a judgment decree by the first court or by the highest court has to be treated as a nullity by every court, whether superior or inferior. It can be challenged in any court, even in collateral proceedings. See the emphasis. Let me read it again. It is the settled proposition of law that a judgment or decree obtained by playing fraud on the court is a nullity, non-est in the eyes of law. Non-est in the eyes of law. Such a judgment or decree by the first court or by the highest court has to be treated as a nullity by every court, whether superior or inferior. It can be challenged in any court, even in collateral proceedings. Para 2. Predecessor in interest of the respondent's plaintiffs filed application for final decree for partition and separate possession of the plaintiff properties and for the means profits. The appellant's defendants contested the application on the ground that a preliminary decree which was sought to be made final was obtained by fraud, and as such the application was liable to be dismissed. See the emphasis. The appellant's defendants contested the application on the ground that the preliminary decree which was sought to be made final was obtained by fraud, and as such the application was liable to be dismissed. It is the contest. It is the focus now. The trial judge accepted the contention and dismissed the application for grant of final decree. The respondents' plaintiffs went in appeal before the High Court. A division bench of the High Court went through SP Changasalaya Naidu versus Jagannath on 27th October 1993. This is the citation mentioned here. Law and finality allowed the appeal and set aside the order of the trial court. The appeal is by way of certificate granted by the High Court. Para 3. One Jagannath was the predecessor in interest of the respondents. He is working as a clerk with one Chunilal Sobachar. Jagannath purchased at court auction the properties in dispute which belonged to the appellants. Chunilal Sovar had obtained a decree and the court sale was made in execution of the said decree. Jagannath had purchased the property in the court action on behalf of Chunilal Sovar. The decree holder, by a registered deed dated November 25th, 1945, Jagannath relinquished all his rights in the property in favor of Chunilal Sovar. Meanwhile, the appellants, who were the judgment debtors, had paid the total decretal amount to Chunilal Sovar. Thereafter, Chunilal Sovar, having received the decretal amount, was no longer entitled to the property which he had purchased through Jagannath. Without disclosing that he had executed a release deed in favor of Chunilal Sovar, Jagannath filed a suit for partition of the property and obtained a preliminary decree. During the pendency of the suit, the appellants did not know that Jagannath had no locus standi to file the suit because he had already executed a registered release deed relinquishing all his rights in respect to the property in dispute in favor of Chunila Suha. It was only at the hearing of the application for final decree that the appellants came to know about the release deed, and as such, they challenged the application on the ground that non-disclosure on the part of the Jagannath that he was left with no right in the property in dispute vitiated the proceedings, and as such, the preliminary decree obtained by Jagannath appealing fraud, the court was in nullity. Let me read again. The appellants came to know about the release deed, and as such, they challenged the application on the ground that non-disclosure on the part of Jagannath that he was left with no right in the property in dispute vitiated the proceedings, and as the preliminary decree obtained by Jagannath appealing fraud on the court was in nullity. The appellants produced the release deed Exhibit B15 before the trial court. The relevant part of the release deed is as under, quote, out of your accretions and out of trust vested in me, purchased the scheduled mentioned properties Benami in my name through court auction and had the said sale confirmed. The said properties are in your possession and enjoyment, and the said properties should hereinafter be held and enjoyed with all rights by you as had been done. So far, if any civil or criminal proceedings have to be conducted in respect of said properties are instituted by others in respect of the said properties, you shall conduct the said proceedings without reference to me and shall be held liable for the profits or losses you incur thereby. The records pertaining the aforesaid properties are already retained by you. Para 4. High Court reversed the findings of the trial court on the following reasoning. Let us focus. Let us assume, for the purpose of argument, that this document Exhibit B15 was of the later category, and the plaintiff, the Binamidar, had completely deserted himself of all rights of every description. Even so, it cannot be held that the failure to disclose the execution of Exhibit P15 would amount to collateral or extrinsic fraud. Utmost that can be said in favor of the defendants is that plaintiff, who had no title at the time when the suit was filed to the properties, has falsely asserted title, and one of the questions that would arise either expressly by necessary implication is whether plaintiff had a subsisting title to the property. It was up to the defendants to plead and establish SP Changasalaya Naidu versus Jagannath in 27 October 1993 Indian Kanun description by gathering all necessary materials, oral and documentary, that the plaintiff had no title to the suit properties. It is their duty to obtain an encumbrance certificate and find out whether plaintiff had still a subsisting title at the time of the suit. Plaintiff did not prevent the defendants, did not use any contrivance, nor any trick, nor any deceit by which the defendants were prevented from raising proper pleas and advocating the necessary evidence. The parties were fighting at arm's length, and it is the duty of each to traverse or question the allegations made by either and to adduce all available evidence regarding the basis of the plaintiff's claim or the defense of the defendants and the truth or falsehood concerning the same. A party litigant cannot be indifferent and negligent in his duty to place the materials in support of his contention and afterwards seek to show that the case of his opponent was false. The position would be entirely different if a party litigant could establish that in a prior litigation his opponent prevented him by an independent collateral wrongful act such as keeping his witnesses in wrongful secret confinement, stealing his documents, to prevent him from adducing an evidence, conducting his case by tricks and misrepresentations, resulting in his misleading of the court. Here, nothing of the kind had happened, and the contesting defendants would have easily produced a certified registered copy of Exhibit P15 and non suited the plaintiff, and it is absurd for them to take the advantage of or make a point of their own acts of omission or negligence or carelessness in the conduct of their own case. Quote, the High Court further held as under. From this decision, it follows that except proceedings for probate and other proceedings where a duty is cast upon a party litigant to disclose all the facts, in all other cases, there is no legal duty cast upon the plaintiff to come to a court with a true case and prove it by true evidence. Let me read it, what the High Court has accepted. From the decision, it follows that except proceedings for probate and other proceedings where a duty is cast upon a party litigant to disclose all the facts, in all other cases, there is no legal duty cast upon the plaintiffs to come to the court with a true case and prove it by true evidence. It will cut at the root of the fundamental principle of finality of litigation enunciated in the maxim. It is if it should be held that a judgment obtained by plaintiff in a false case, false to his knowledge, could be set aside on the ground of fraud in a subsequent litigation. Finally, the High Court held as under. The principle of this decision governs the instant case. At the worst, the plaintiff is guilty of fraud in having falsely alleged at the time when they filed the suit for partition, he had subsisting interest in the property through he had already executed Exhibit B15. Even so, that would not amount to extinguishing fraud because that is a matter which could well have been traced and established to be false by the appellant by adducing the necessary evidence. The preliminary decree in the partition suit necessarily involves an adjudication through impliedly that the plaintiff was a subsisting interest in the property. Para 5. The High Court, in our view, fell into patent error. Let me put it with emphasis. The High Court, in our view, fell into patent error. The short question before the High Court was whether, in the facts and circumstances of this case, Jagannath obtained the preliminary decree by playing fraud in the court. High Court, however, went haywire and made observations which are wholly perverse. We don't agree with the High Court. We do not agree with the High Court that there is no legal duty cast upon the plaintiff to come to court with a true case and prove it by true evidence. The principle of finality of litigation cannot be passed to the extent of such an absurdity that it becomes an engine of fraud in the hands of the dishonest litigants. Courts of law are meant for imparting justice between the parties. On which comes to the one which comes to the court must come with clean hands. One who comes to the court must come with clean hands. We are constrained to say that more often than not, process of the court is being abused. Property grabbers, tax evaders, SP Changshalai and Naidu vs. Jagannath on 27th to 96, so and so. Bank loan dodgers and other unscrupulous persons from all walks of life find the court process a convenient lever to retain the illegal gains indefinitely, see the observations, see the finding. Other other unscrupulous persons from all walks of life find the court process a convenient lever to retain the illegal gains indefinitely. We have no hesitation to say that a person whose case is based on falsehood has no right to approach the court. He can be summarily thrown out at any stage of the litigation. Para 6. The facts of the present case leave no manner of doubt that Jagannath obtained the preliminary decree by playing fraud on the court. A fraud is an act of deliberate deception with the design of securing something by taking unfair advantage of another. It is a deception in order to gain by another's loss. It is a cheating intended to get an advantage. Jagannath was working as a clerk with the Chunilal Suvar. He purchased the property in the court auction on behalf of Chunilal Suvar. He had, on his own volition, executed the registered release deed, Exhibit D15, in favor of Chunilal Suvar regarding the property in dispute. He knew that the appellants had paid the total decretal amount to his master, Chunilal Suvar. Without disclosing all these facts, he filed the suit for the partition of the property on the ground that he had purchased the property in his own behalf and not on behalf of Chunilal Suvar. Non-description of even non-mentioning of the release deed at the trial tantamounts to playing fraud on the court. Non-production, even non-mentioning of the release deed at the trial is tantamount to playing fraud on the court. We don't agree with the observation of the High Court that the appellate defendants could have easily produced the certified registered copy of Exhibit P15 and non-suited the plaintiff. A litigant who approaches the court is bound to produce all the documents executed by him which are relevant to the litigation. If he withholds a vital document in order to obtain advantage on the other side, then he would be guilty of playing fraud on the court as well as on the opposite party. We therefore allow the appeal, set aside the impugned judgment of the High Court, and restore that of the trial court. Appellants shall be entitled to their costs, which we quantify at least 11,000. Please be through this judgment more than once. Imbibe the ratio of this judgment. The ratio of this judgment is that party coming to a court must plead all the true facts of his knowledge being relevant for the cause and adjudication. This judgment makes it very clear that the fundamental principle of civil justice in our country is that everyone who is a party to the litigation is bound to produce all true facts of within his knowledge. The facts within one's knowledge, if withheld, will amount to playing a fraud, and fraud will make orders obtained as non-est. Thank you very much.